The second capsule in the subtheme Gender, Constitution and Law is on fundamental rights, directive principles of the state policy, and specific provisions for women that is there under these in the Indian Constitution. It is important for us to remember that the fundamental rights and the DPSPs of the Indian Constitution follow from the preamble of the Constitution, the broader philosophical basis through which the Constitution is imagined. And we've already discussed in the first capsule about that very briefly. The kind of fundamental rights that is guaranteed in order to ensure equality of status, equality of opportunity, social, economic, and political justice for women come under some of the principles of the Indian Constitution. Number one being Article 14 of the Indian Constitution, which talks about equality before law and equal protection by the law, and very clearly it would include all women within this provision of granting equality. The second is Article 15(1) of the Indian Constitution, which very clearly is the fundamental right that guarantees non-discrimination. Non-discrimination on the basis of sex, but also race, caste, religion, language, place of birth. Much later, through Supreme Court judgments, non-discrimination on the basis of sexual orientation has come to be included or interpreted under non-discrimination on the basis of sex, under Article 15 of the Indian Constitution. Article 15(3) of the Indian Constitution talks about that the state can make any special provision in favor of women and children. Now, what is important for us to remember is that the Constitution of India was constantly trying to balance political equality with substantive equality, or legal equality, formal legal equality with substantive equality. So while Article 15(1) of the Constitution was guaranteeing non-discrimination on the basis of sex, while Article 14 was guaranteeing equality for everybody, including women, you also had Article 15(3), which was talking about special laws and special provisions that can be made for women and children. The importance of this, as well as the far-sightedness of the framers of the Indian Constitution about this, is that just by guaranteeing non-discrimination and equality does not necessarily mean that years and histories of social and patriarchal oppression against women will stop. And that is the reason why, together with guaranteeing equality and non-discrimination, special provisions are needed for women and children in order to address this presence of patriarchal oppression, this presence of domination that women face in societies. That is the reason why you have special laws for women and children. So it's important to understand the special provision for women and children as complementary to the fundamental right on non-discrimination and equality. A fourth thing that we have to remember is Article 16, which says equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. The other provisions which touch upon women's lives in the Indian Constitution are Article 39, which says that the state would direct its policies towards securing for men and women equally the right to adequate means of livelihood as well as equal pay for equal work. Now, this is Article 39 of the Indian Constitution, which comes under the directive principles of state policy, which is non-justiciable. But at the same point of time, the DPSPs play a very important role in terms of the socialist vision and futuristic dimension of the Indian Constitution. Another important provision under the directive principles are to promote justice on a basis of equal opportunity and to provide free legal aid by suitable legislation or scheme or in any other way to ensure the opportunities for securing justice are not denied to any citizen for reason of economy or other disabilities. So the Constitution from the very beginning is actually talking about access to justice, and that nobody should be denied access to justice based on gender, class, or any other kind of social disability. Two other important provisions in the DPSPs specifically for women are that the state would promote special care to secure just and humane conditions of work and for maternity benefit and maternity relief. Another of these provisions say that the state would attempt to raise the level of nutrition and the standard of living of its people. It is under some of these directive principles of state policies that we, at a later juncture, had separate laws around the Maternity Benefits Act, which was first promulgated in 1961. We had the Medical Termination of Pregnancy Act in 1971. The Maternity Benefits Act was 1961. The Medical Termination of Pregnancy Act was 1971. The Equal Remuneration Act was 1976. And the Dowry Prohibition Act was in 1961. Special provisions for women and children, which continued later with Protection of Women from Domestic Violence Act 2005. The other specific to women provision with respect to the Indian Constitution that we need to remember comes under the fundamental duties. The fundamental duties to the Indian Constitution came in 1976. And one of these articles, Article 51AE, talks about the need to promote harmony and the spirit of common brotherhood amongst all the people of India and to renounce practices derogatory to the dignity of women. That is one of the fundamental duties that is there, that is enshrined in the Indian Constitution. Together with this, it is also important for us to remember some of the special initiatives that have been taken, and more in terms of institutional initiatives that have been taken for women. The first of it being the National Commission for Women, the setting up of the National Commission for Women in 1992. The second being reservation for women in local self-government. And that happened through the 73rd Amendment of the Indian Constitution, which also took place in 1992, which ensured that 1/3 of the total seats for women in all elected offices in local bodies, whether rural or in urban areas, would be reserved for women. A third was the National Plan of Action for the Girl Child, which was between 1991 and 2000. And a fourth was the National Policy for the Empowerment of Women 2001. Together with all of this, the other important, not an institutional initiative, but a research initiative that was taken, came out through the publication of the Towards Equality Report of 1974. And that came from the Committee for the Status of Women in India, a Government of India initiated committee. So through all of these fundamental rights, directive principles, fundamental duties, and these institutional initiatives, which is either enshrined in the Constitution or which follows from constitutional principle, we understand the principle and the philosophy of recognition which is part of the concept note of this refresher course, the principle and the philosophy of recognition. Recognition of women as equal citizens of this country, recognition of women who will be able to get equal opportunities in jobs, recognition of women that given their specific social and historical and cultural context, there can be special treatment that they constitutionally and legally deserve. And finally, recognition of women towards ensuring their dignity.